We'll officially call the policy committee meeting to order. It's Zachary Epps, co-chair of the committee. I'll go through, take roll call, starting to my right.
Pam Henry.
Charles Burdell Williams.
William Mulhern.
Robin Murphy.
And Ms. Lohman is online.
Thank you, Ms.
Hi,
Lomas.
good evening. I'm here.
And I'll wait a motion to approve for the 9 minutes.
So moved.
Second.
All in favor?
Aye.
Aye.
With the minutes approved, I'll hand it over to administrator.
We have a number of policies on the agenda for old business. We can go through them. I guess we can go through them individually. None of these have had revisions other than those that were discussed at the last meeting. So we can start with 259, which is students experiencing homelessness, foster care, and other educational instability. So previously, the policy's scope was limited to just homelessness. And since for foster care students and students that are experiencing educational instability, they get sort of the similar protections as homeless students. The one policy covers all groups of students.
Sorry, was that? That's it? Yeah. That's fine. Opening up to comments from the board.
No.
Do we have any members of the public online? Just so,
I don't
No.
see any.
we'll check another time later.
Wait. Yes,
Oh, we do. Okay,
we have 3.
okay. So
It's Ms. Keen,
oh, okay.
Ms. Lohman, right? And
Go under attendees. It's Donna M, Melissa, and Sarah Nuts.
oh, we do have a few. Okay.
Okay, we'll just be mindful of that as we open up to, any comments from members of the public on policy, 259.
No hands raised.
And if we just, if we have any first time, are you a first time visitor?
I am.
Oh, good. We might as well keep it, I'm looking at it right now. So, as we go through the agenda, just for the, not just, you're the only here, what's your name? Caitlin, okay, so you actually emailed us
I
about a
certainly
specific policy.
did.
So that's what I wanted to mention. So as we go through the agenda, we will take comments from the board and comments from the public on each policy as we're, each at a time. And I know you're here to talk about a policy that's not on the
Because it
agenda.
could fall under
And
wellness.
so, which,
It could probably fall under wellness.
we talked
That
to
was
our
a very
solicitor,
specific
we can
policy.
accept, we can accept your comment about whatever policy. We'll have a moment where we can accept your comment about the policy 262, even though it's not on the agenda. And then if appropriate, we'll be able to, the admin's gonna talk, and then based on that, we may bring it to the next meeting's agenda. So just want to let you know, if you sit here and you're like, all right, I don't hear 262, I don't hear 262, it's not on the agenda for tonight
Well, yeah, I
officially,
didn't
but
think
you'll
it
still be able to make a comment a little later.
Okay.
And so for members of the public online, as if you've been here before, as I mentioned, you'll be able to comment on each policy as we address it. And then if there's a policy that we haven't addressed that you'd like us to address, feel free to make that comment known in the chat or verbally. So excuse that interruption, but I think I'll just take another call. Are there any comments for 259 from the members of the public before we go forward?
No hands. No hands raised.
Right, that policy will move forward for consideration for adoption at our next legislative meeting, and we'll move forward to the next agenda item.
So the next one is homebound instruction. We had some discussion at the October meeting around homebound instruction. We added language at that meeting regarding the fact that sometimes homebound instruction can be virtual, can be a virtual or in-person support that's available for students, but otherwise the policy remains unchanged from the changes that we discussed last meeting.
And that's 117.
117, correct.
Opening up for any comments from the board on 117. Comments from the public on 117, homebound instruction.
I don't see it.
No hands.
Okay, that policy also will move forward for adoption at our February legislative meeting. I'll go forward to 254, student wellness.
Yes, so no changes to this one. I think we did select, who was our board? We picked a board member. Last time around.
I think it was Jenny. Jenny, were you on the student wellness?
I think it might have actually been Mr. Whiting.
I think that's right.
Was it?
That's what I thought as well.
Yeah.
But
Let's sign him up.
Oh, right, he's not here, so go ahead. It could be him.
I thought it was Mia, was it?
Oh.
I don't know if you guys can hear me. I think it was Mia Blitzstein.
Oh, okay, there we go.
Anybody wasn't here.
If you need someone to do it, I'm happy to.
Okay.
Yeah, in my notes.
is, well, that's
Yes,
a topic
that's
for another time.
Sorry.
Much of the policy here is dictated by federal law in terms of having a policy, having it address certain topics, nutrition, physical activity, all those types of things.
Opening up for comments from board.
No comments.
Recognizing this is the second time we've seen this policy at the committee. And we'll open it up for members of the public. Any comments, questions on policy 254?
No hands. We have 5 members of the public, but no hands.
Would
Do you want me to
you,
bring up
I mean,
my problem now?
what do you think, Mr. Diaz?
Yeah, I would let her.
Sure.
Yeah, okay.
Sure.
Cool.
Okay.
So please, and you would need to state your name
Okay.
for the record, the neighborhood you live in, and then you have the floor.
Okay. My name's Caitlin Patisol. I live in Glenside. My children go to Glenside and I have a student at EP. And my concern is recess policy. Children are being kept indoors when I feel the policy is not being met. Policy requirement is not being met, right? So the policy states that they are to have outdoor recess unless there is a wind chill warning or a frost warning. I believe that's the policy, and they're being kept inside when the real feel is 32 degrees. And I just don't think that's appropriate for wellness, for physical activity, for their emotional, wellness. I brought it up with the principal, who then kind of reiterated, we use the real feel, whatever. I've called the school on several occasions when it's sunny and the temperature is well above 32 degrees and they are indoors. And so that's my biggest concern, but also during recess time. Now, this might not be appropriate here. It might be, I might have to deal with this with the school directly. They're not allowed to run and chase. There's no balls, there's no jump ropes. I don't know if your kids read Wimpy Kid. Anybody? But the recess is Wimpy Kid recess. They're not allowed to do anything or have fun. And I feel like it's really putting I think it's putting a burden on them. They're very upset when they come home. They have full of energy. They're not running around. And I think it needs to be addressed.
So recognizing as I mentioned, this isn't the exact policy, you're representing policy 262. And so while physical activity is referenced, I think, in this 254 and AR, I think part of what you described, and for full I guess transparency, you did send the board an email.
Correct.
I think it had some details
And
in
it had the entire chain of email
Right.
that,
So I think part of it is, you were right, the conversation having with the principal about what is actually happening, you know, in terms of implementation. I think at administration, that's literally what I was gonna say, if administration wants to chime in.
Yeah, so we had an opportunity to speak today. We're gonna do our due diligence in terms of having the necessary dialogue with our principals. If there's other factors like you mentioned, restrictions during recess or what have you, please feel free to forward those as well.
okay,
And what we're going to do is just, when we know that we have situations where weather may be an issue, administratively, we are going to forward guidance directly to our principals across the district so that we have consistency. The one thing which I don't believe was mentioned that we discussed was she has students that are
Right.
both
I
at
was gonna
Glenside and Elkins Park. And, you know, one thing may be happening at Glenside, but yet a different set of rules are being followed at Elkins Park. So we want to make sure that we level set and that there's consistency across all schoolhouses. So there's some upgrades that we're going to put in place, but I need to take a deeper dive.
right. I
So
mean, who's determining real fuel? Where is this information coming from? Who's making the decision? Is it just, you're looking at your phone and saying real fuel is 31, can't go outside even though it's sunny and 40 because the wind blew, like, you know.
we're going to come up with clarity. That's going to be our work, and we'll be able to circle back to you.
Thank you.
So to that end, I think part of your conversation is happening at the principal school level. And so based upon that, we will see if we need to redress the policy formally at a future meeting as well. So back to 254, I think we're good to move that forward for consideration for adoption at the next meeting.
Okay.
We can move forward with the agenda.
So 207 is the next one, confidential communications. Students, we talked about this one last time we were together. We removed from the administrative regulations some guidance that was sort of antiquated, outdated, and a lot of issues around topics with pregnancy and things like that are already addressed in other policies. Non-discrimination, Title IX, things like that.
I'm sorry, there's a hand up. I don't know if it was up for
Oh,
recess discussion or.
Yeah, good point.
oh, so, yeah. so
Sarah Nutt.
She's one of the
Oh,
ones.
she's reasons.
Okay.
Yeah,
I almost said we should check.
so if she wants to give a comment, that's certainly fine.
Yeah, so we'll.
You have to
She
unmute.
said chat was blocked.
It's here, we see it.
Yeah, ask her, well, Sarah, if you can hear us, let me see if you're
Oh, yeah,
able
it's
to, go to the,
Do you want
go
me
to-
to allow her to talk?
Yes, please.
Okay, I'll do it now.
Okay, somebody can unmute her, right, so she doesn't have to write it into the blog.
Hi, Sarah, you can talk now.
Hi, how are you? Can you hear me okay?
Yes, and if you could, same thing, you could mention your name and neighborhood and then your comment for the record and then your comment.
Oh, okay, fantastic. Good evening. My name is Sarah Nutt. I have children at Glenside Elementary as well as Elkins Park Intermediate School. And I'm here as well just to kind of hear a little bit more about our recess policy because it's a concern to me as well. I think what's challenging is that we did reach out to the principal and the reply didn't really feel like we could really go anywhere from there. And so I think just trying to figure out, okay, so at what level do we have these discussions? And so I think, Dr. Scriven is aware now and has said he's going to, check around and do his due diligence. And so I think that's kind of all I wanted to just state, was that I appreciate you looking into it and hearing our concerns. It is recess is a hill I'm willing to die on, especially because I have 3 boys and I understand the importance of moving their bodies, particularly in a very high pressure cooker environment where recess is quite pitiful, even at a baseline. And, with all this emphasis on PBIS measures and implementing better behavior, taking away recess is really not going to help that. And so that's a big concern of mine, that if we as a district are going to prioritize these numbers and these statistics and have PBIS like a sole focus of our children's day, we also can't lose sight of the need for them to expel a lot of energy. And so thank you for hearing our concerns. And yeah, I think it is sort of a district-wide issue, which is partly why we felt like maybe we should show up at the policy meeting, because I did have a son at EP who had outdoor recess, and then I had elementary kids that did not go out. I'm also being told recess is being withheld due to behavior, which I know is not a policy in the district. Is my understanding was that you're not allowed to use minimizing recess as a punitive measure. And so that's kind of a whole nother thing I'll look into eventually. But, I'm definitely a little concerned about the things that I'm hearing surrounding recess in our schools. That's it. Thank you so much.
So Mrs. Nutt, feel free to shoot that to me, any wonderings or concerns that you have, so I can try to touch all this at the same time.
Thank
And
you. I
could you-
appreciate it.
Could you let us know what is your neighborhood? That's our legal.
Oh,
the-
sorry.
The neighborhood you reside, the legal requirement, sorry.
Okay. I live in Twickenham Village. Is that the neighborhood you're looking for? I'm not sure. It's Augustus Woods, Twickenham Village.
Glenside, yeah, yes.
Yes. We're Glen. Sorry. Glenside Elementary, and Glenside is my mailing address. Thank you.
Okay, thank you. Just in closing, as we go forward, using the words of our even superintendent, we have trust, but you can also verify. So trust and verify, we definitely trust that, administration's attention is to this, but I appreciate you all emailing us, coming out to the meeting, because you're doing exactly what you should as parents. And so thank you. And like Dr. Scriven said, some of the things we have to be made aware of in order to investigate. Appreciate it. So we'll move forward in the agenda.
Sure. So 234 is the next one. Students experiencing pregnancy-related conditions or parenting. This was a cleanup policy or an ancillary policy that we had to just take a look at to ensure that the language was consistent with our non-discrimination policies that we reviewed as a result of the new Title IX guidance. As the committee may be aware, the 2024 Title IX guidance has been revoked or put on hold, but that's not going to require policy changes because there are still, the 2020 regs are still in place. And really what was different about one of the big things that was different about the 2020 regs and the 2024 regs was protections for gender identity, gender expression, sexual orientation. All of those protected classes are still protected classes at the state level. So even though the federal guidance doesn't necessarily cover those topics, state law does.
Opening up to comments from the board.
See anyone's hand
Just
raised.
one.
Yeah.
Just kind of, I just appreciate the comprehensiveness of the additions that have been made to the policy, kind of thinking of various scenarios that a student may encounter while they are pregnant and or parenting. And so just appreciation.
Yeah, we have 258 a little later on the agenda. but to hear, you've already answered one of my questions, because to hear that there are some state protections in place, even though the conversation at the federal level is what it is at this point.
Correct.
There's still some state protections in place. I appreciate that as well. Opening up to comments from the public on policy 234 AR.
There are not any hands raised.
That will also move forward for consideration for adoption.
247 is the next policy that we discussed last time. It looks like a new policy because 247 was previously the bullying and harassment policy. All of the harassment language was moved to policy 103 and 104. So bullying is now covered as a standalone item in 247. And we'll see in a moment, the next policy is 248 on hazing. And they're similar policies in a lot of ways.
Welcome. We will take any comments from the board on policy 247, bullying.
No one online.
Members from the public. If by any chance you came here to talk about the bullying policy tonight, did you? Okay, we're just about to move forward, so I just wanted to check just in case. All right, so I'll pass it back. That will also be considered for adoption at our February meeting.
And then we can go to 248 hazing. Very similar to the bullying and the students experiencing pregnancy. These were just policies that needed minor tweaks to ensure consistency of language and reporting procedures for Title IX.
Any comments from the board? Got that sentence right around forceful activity. I know we had a conversation about that last time. So that is clear in terms of that no matter what it is, it's presumed to be a forced activity. So thanks for that. Any comments from the public on policy 248?
No hands raised.
That will be considered for adoption at our next meeting.
So our last one on old business is 258, which is gender expansive and transgender students. Again, minor revisions to this policy to ensure consistency in Title IX. Just scrolling through here, there was really no other change to this policy. This was one we had looked at not too long ago.
Opening up to any comments from members of the board?
I do have one question for Ed. Ed, with the rollback to Title IX, the communication that just went out, it did not have any language in there that would impact this.
Correct.
Okay.
Correct. So Cheltenham's non-discrimination statement includes prohibitions regarding discrimination and harassment on the basis of gender, sexual orientation, gender identity, gender expression, all of those protected classes, and they remain entirely intact, and they are protected at the state level.
Right. All right, thank you.
Any comments or questions from members of the public on policy 258, gender expansive and transgender students?
There are no hands raised on Zoom.
Right, and again, before we move forward, I'll just express appreciation that we are in a community that is striving for belonging, no matter a student's identity, no matter a teacher, a staff member's identity. This is a place where you will receive inspiration and resources to reach your full potential, and that's something that we should hold high, just as we do every day, but just even more so for the times that we're in. Hand it back to admin.
Sure. So now we can move into our new business policies for the evening. The first one is 916 on volunteers. This one came up because there's been some questions. And once a question comes up 2 or 3 times, then, maybe it's time to clarify your policy. There were some questions around the TB test requirements for volunteers and when they were required and when they weren't required. So what's required is that, and this is a state requirement, this is not just a requirement that we made up. Volunteers who have direct services and direct contact with children for more than 10 hours per week are those that are the volunteers that need to have a TB test. That's generally pretty rare. So people that sign up to be to go on a trip, or they help out in the classroom once in a while, it's rare that on a regular basis a volunteer would be having direct contact, not even just being in the school, but direct contact with students for 10 hours a week. So we added that provision to the AR, and also clarified that the initial approval of volunteers happens internally, and it's only after the administration sort of internally approves volunteers, making sure that they've submitted their child abuse clearances, that they've gone through the background check requirements. Only then are they subsequently presented to the board to sort of be ratified. And that's the action item that we see monthly from the board regarding the approval.
Ms. Merkin,
I have a question.
please.
So when you talk about the TB test, as someone who tested positive almost 20 years ago and always will test positive,
Right.
how often, because they want you to take a chest x-ray. So how often does that come up? Is it an annual? Because from my own experience, getting a chest x-ray every year is really
So you only have to,
not safe.
as I understand, you only have to get the test one time.
It's only one time, and they only do have a blood test that they can do as well, that we accept, other than the x-ray.
Ms. Moore, and then Mr. Barbour. Very well.
One time for 5 years when you go to get your next round of clearances after 5 years has passed.
Technically, the TB test, there's no interval requirement.
And I think that's as like a parent and a volunteer, I think that's where the confusion has laid, because that has not been clear. And when you read the requirements, or when you ask for the requirements, that the TB test is always on there. I did it for my second time just a year or 2 ago, and I went to my doctor because that's what I was told to do.
Okay.
So maybe it's not so much our policy, because I hear what you're saying, that it's the direct contact for 10, which we have very few volunteers that would fall under that. Even our busiest volunteers I don't think have. So I guess my question is, 1, making that very clear.
Yep.
And then 2, I guess, how do we then delineate those volunteers that need it? Like, how is that decided or figured out, or, because it sounds to me like what you're saying is the average volunteer, parent, guardian who is doing their clearances because they want to go on a field trip doesn't need a TB test at all then.
Right, correct.
Okay. And that has, in my experience, has not been the guidance that has been given.
And that's one of the internal procedures that Mrs. Savage and I discussed, was that we were actually doing too much with volunteers and we were just trying to bring particularly the TB test requirement back to what the state requirement was, because we get it that can be a burdensome requirement. So I think what I'm saying to you is, I acknowledge that based on internal conversations, what this policy says may not have been what was actually happening before. It was as a result of conversations internally, looking at the law and actually saying, actually, only this is what's required. Let's get our policy right. And my guess is that once this gets approved, a new procedure will be implemented.
And then that will figure out who needs to do which. That makes complete sense. Thank you for the clarity.
So Ed, I have a question on what Ms. Murphy asked about. So in situations where somebody tested positive years ago, and now they want to be a volunteer, what happens if they have to be tested and they tested positive, means it's always gonna be a positive result. And I know it probably doesn't come up often, but what made me think about it, I saw in the news today that TB is on the rise in the US. So I was just wondering, like, what would happen in that situation?
My understanding, this is what we do with new
Mhm.
employees who can't take that, who always get a positive.
Right.
They have a blood test now.
Okay, so it's the blood test that,
And the blood test, yes, well,
Okay.
some person, some people who usually always come up positive, that won't happen with the blood test.
okay.
Yep, so I do appreciate the comment, and just kind of the response about what's the true delineation between who's getting an TB test or not. And I guess for me, looking at the language that we have, I'm wondering if there's an opportunity for us to maybe clarify something. So I'm looking at the statement, around volunteers who provide direct services. Like if you do go on like an overnight trip, that would technically be greater than 10 hours. Now, I think it implies when we have per week that we're talking about some type of reoccurrence.
Right.
But I don't want to imply necessarily. I think maybe there's an opportunity for clarity. Because I think there's like some kind of routine, 10 hours of like maybe routine, looking at the remainder of the, and I'm looking at the AR specifically here. And I know that typically, board input on AR is welcome, but that's where the majority of the information lives on this one, because the policy is actually very, very
Right.
So I'm curious if there's an opportunity to clarify, because if a person does only go on one trip and it is an overnight trip, they are greater than 24 hours. So just thinking about that, and my own public health hat being on right now, if we want to be specific, we should probably be specific.
I'll talk with Mrs. Savage after this meeting, since this is only going for a first read, and since it's only an AR, we can tweak it.
Yeah.
My sense is, well, what I know is that the guidance from the Department of Health only says what it says on the screen here, 10 or more hours per week. We can make an internal decision about what does it mean if it's going to be one time 10 hours. And that, I'll talk with Mrs. Savage and see if she has a recommendation that she wants to make to the board.
I appreciate that. Thank you.
As we go to members of the public, I'll note this, what you're witnessing is an example of emails to policy AR change. So we had some emails and messages around the need for TB, and we are addressing it at this level at this time. So hopefully that's some encouragement. You happen to be on a night where, where the advocacy actually turns into conversations as well. So we can move, that will also move, these are first reads, so we'll move forward to a first read. Each policy gets 2 reads at our legislative meeting before it becomes official. And so this will get a this will be considered for the first time. It'll come back to the policy committee. It'll go back to legislative for a second read. And at that point, we can consider it for formal adoption. We can move forward in the agenda.
So next one is 219. This was just a routine review policy. It has a last review date of 2016, so it was one of the older policies. It was redlined. It's fairly heavily redlined, although this is not a policy that comes up very often. The more important piece of the policy here is this first paragraph or first sentence of the guidelines that tells you when you use this policy. And it comes about when there's complaints about a school program or activity, including extracurriculars, when students feel that they've got some type of grievance as a result of those programs or activities, and they need to present a concern. And there's just a chain of command type process in the AR as to how you can have those grievances or complaints heard. So you start with a staff member. If it's unresolved, you kind of move up the administrative chain all the way up to the superintendent, and ultimately to the board if it's something that the board would need to decide on. So again, it's not a policy that comes into place very frequently, but something that's good to have on the books.
Open up for any questions from the board.
I have one, actually just a comment. First, the comment about the AR, I appreciate how the AR flows now. There was a lot of words.
Right.
In the previous AR. This is very easy to read and digest. 3 lines, 3 paragraphs, get to the point. Thank you. I appreciate how simple that is, given some of our policies are quite lengthy and they can be for good reason, but the question or other comment I have relative to the policy is really simple. Under authority in that paragraph, it states the board and its employees. And I just wanted to, I guess, highlight the fact that we don't have any employees.
Should say district employee.
So we might want to just update that to district employees. I don't think I do, unless I do. I don't know.
Checking.
The authority, right?
Yeah, under authority.
I see it.
Thank you. Good people managing that space. I'm not gonna pretend to be one.
There you go.
Mrs. Murphy, did you have? I'm a trained professionals.
Quick, just a question. You said this doesn't come up often. And so, is that as I've read it, I know we had, so for specific types of complaints, like we just talked about bullying and hazing,
Correct.
harassment, and things like that, there's a process for those types of complaints. So this is like if a student, like literally about a specific programming, doesn't like the programming.
Sure. So I'm just going to give a hypothetical here. There's a GPA requirement to be in National Honor Society. And the student doesn't feel like their GPA was calculated the right way, and therefore they didn't get into National Honor Society. Or there's a club or an activity that requires you to be in school for a majority of the day, sometimes like in athletics, right? Like you have to be in school by a certain point in the day in order to be eligible to play after school, right? And if the student believes that they were not allowed to play because of a disagreement about how the attendance policy was applied to their situation, those are the types of situations that sometimes come up where we say, okay, we can take a look at that and start with your teacher, start with your principal. If it doesn't get resolved at that level, then you can you get like a central office administrator and then ultimately.
So we're not talking about grades, like complaining about grades.
Correct, because it has to be about like a school program or activity.
And then that's, I guess this goes to the AR, which is more admin. But I just wondered, given these types of complaints, I guess it makes more sense that you would go to the teacher and, and someone would probably feel comfortable going to the teacher in that case. So I guess I'll reserve the next comment. Thanks. And then, the last piece was, I think it requires the student to write the complaint. But then there's not in the AR complaint resolution process, it's like if nothing happens, it has to be submitted in writing. And so if they submit something in writing, I just think it's fair, other than the second one, prepare a written statement complaint, that they receive something back. In writing.
So number 2, you said?
Yeah, for complaints that remain unresolved, the student shall prepare. So when I saw that shall prepare,
sure.
That seems like they have to prepare that. So just as a matter of record keeping and just due diligence, it might be something to consider, actually, that they would receive something back.
And we don't say in here that they won't get, it's that something needs to be added, correct?
Correct.
All right.
It doesn't say that we won't.
Right,
It
okay.
just, it requires that they do,
All right.
but it doesn't require
We'll
that.
add,
the district
we can
does.
add that language. Response.
Any comments from the public?
No, there are no hands raised.
move forward. That will also again move forward to first read and.
Okay, now we can go to 237, which is the student use of personal device policy. This policy, again, was actually just looked at because it had a 2017 date on it. There's no actual substantive changes to the policy or the regulation. With the exception, we just wanted to make clear that what has always been the case is that there are certain baseline rules that apply to devices everywhere. So you can't use them in a way that is disruptive to the educational environment. You can't use them in a way that violates the law. You can't use them in bathrooms or in things like that. Those rules apply to everyone as a threshold matter. But the policy in the AR then also gives building administrators the ability to regulate use of personal electronic devices in their building, as long as those regulations of the building principal don't contradict these baseline rules. And the reason there is, in a K-4 building, the rules might be different than in a high school or a middle school for that matter. There's nothing in here beyond that.
Mr. Burdell.
So item 8 strikes me as, in some way, I could only imagine how challenging it could be to actually enforce that, thinking about our lunch and learn and community lunch environment. Having the understanding, right, that is an opportunity for students to kind of engage freely and just, again, this is the AR, not the policy. So just thinking, just from a recommendation perspective, is there an opportunity to improve the language? Because I'm thinking, right, specifically about lunch and learn at the high school, where that's not explicitly open to the general public. It's still a part of the school day, unless I'm wrong, but that I would expect that time is being used to make TikTok videos. I'm going to assume that it is, but I'm doing that with a significant amount of firsthand knowledge. Not having seen any said videos, but
We saw them filming.
we saw a student who literally had 300,000 views on a TikTok video that they had recorded in high school. Now, the student was very encouraged. I was very encouraged by that amount of publicity for that student. Leah and I were absolutely amazed. But maybe there's an opportunity here, seeing that and seeing how our culture and the lives of our students are evolving, if there's an opportunity for us to broaden the language in a way that makes some use of that phone during, I'm not going to say specifically to lunch and learn, but maybe there's something other than events which are open to the public.
So when we drafted this language, the context might be helpful. So when we drafted this language a number of years ago, it came following the series of fights
Correct.
the district was navigating. And at the time, there are advocacy groups out there that when you don't allow students to record or film certain types of things, but you let them photograph or film other things, you run into legal challenges with the First Amendment. And there are groups like the, ACLU and other groups that look to make sure that school districts are applying the rules and applying the law consistently and fairly. So at the time, in addition to not wanting students to record misbehavior and post it in inappropriate ways in public settings, or the possibility that students would take photos or videos in a way that would be harassing to other students, we had to weigh, do we want to allow recording or do we not want to allow recording? And at the time, the recommendation from the building administrators was the default should be you don't do that unless there's permission. there's no photo police walking around the schools, right? Usually this only comes to the attention of a building administrator in connection with some other infraction of the rules. So you were fighting, and in connection with the fight, well, people recorded it, or you were harassing someone and there was a complaint of harassment, and as part of that investigation, some of the evidence that comes forward is videos that you took of the student. So it's a balancing act that we had to really walk a fine line on. So we can reopen that discussion, but I just wanted to give the context of the two alternatives that we were choosing from at that moment in history.
That's a good point. I think the last sentence kind of like, I guess that's like what Lunch and Learn is, right? So I guess it is, related to curriculum or district sponsored activity. Like I can see that. I just my thought is not necessarily that we open it up completely, but just that we're not putting ourselves in a compromising position where we're like district authorized or sponsored activity. Like, are we saying explicitly through Lunch and Learn that it's acceptable for you ever to use it, or is that just happening on a case by case basis and someone walking by just kind of acknowledges it in the hallway? So I'm just, maybe it doesn't happen here, maybe it happens in another place, and I'm not going to necessarily like dive into how the administration may want to manage if they think they want to change anything in any way. I just would not want there to be ambiguity.
Sure.
Is this district sponsored? I mean, yeah, I could assume that because we're telling the kids that it's okay to do Lunch and Learn as a part of your schedule. So the district has authorized that. But just thinking about what could become a conflict in that is just really where my comment was.
Okay.
So what's interesting, Charles, and your comment too, and I'm looking at like on that number 8, and it says, unless authorized by and sponsored. But coupled with that is the reality that kids are in the lunchroom and they're doing videos and nobody's paying that any attention. I mean, let's talk about the reality of it too. So.
Yeah.
And I don't know how finite, to your point, I don't know how finite we can get.
Yeah, I don't know if we can. I'm just, for me, you're right. I think where I fall back is just that we are not creating an ambiguous situation for parents, teachers, or administrators, that everybody's but everybody's aligned on like what
This
these
is
uses
also
are.
on the heels of just having been with some folks that were asking about us banning
Sure,
or wanting us
certainly.
to ban the use of electronic devices in schools, like altogether.
Yeah, I mean, I think that's definitely an extreme. Sorry to but just not in a rebuttal. But I know in our board work that is a discussion that's happening not just in our township but in those around the country, and it's happening. It's already enforced in many places around the country as well. So I'll leave it at that. It was just a comment for me. If there's an opportunity for it to be less ambiguous, then I would want administration to just take a look.
We can take a look at that in advance of the next meeting as well. Okay. Check and see if there's any hands. It doesn't look like there's any.
Okay.
We got one in the room here.
Caitlin,
You don't need to
Okay.
restate it.
I think no phones in schools is a wonderful idea. So that's all I have to say about that.
All right, thanks for the conversation and comments. We'll hand it back over to admin to move forward.
Sure. So we will move to policy 202, which we had actually just looked at not too long ago, but there were recently some revisions to the school code, which require that anytime the district determines that a student is not a resident of the district, before there is any sort of disenrollment, they have to be offered a hearing, or there has to be a court order, or they have to decline to participate in a hearing. So that the language that you see here is the language from the state statute. We wanted to take the new provisions of the law and make sure that they were embedded into our policy. Otherwise, the general scope of the policy is the same.
Any comments to members of the board? No, Mr. Bordello.
So this one, the timing is definitely interesting because I think it was at January's legislative meeting where we did approve or have to review and approve the, I guess it would have, now I'm missing the actual, decision description, but I believe it was disenrolling, of a number of students in the district. I recall when reviewing each one of those disenrollments that the hearing took place, and after some amount of time,
Correct.
an individual didn't show, and so that concluded the hearing, and then so it did conclude their opportunity to appeal or work through the disenrollment. So I guess for me, thinking about that and looking at again, I'm in the AHAR, not necessarily in the policy, but just, and maybe it's not necessarily answer for right now, but just curious about how does administration contact the individuals and
After a hearing.
no, to schedule the hearing. Right?
So that goes, so anytime there's going to be a hearing, and that's set out, it's actually set out in the law. It has to go certified mail. It has to be received three days in advance. We also, by policy, send it by first class mail and email. And generally, there are phone calls also made. And the family knows that the hearing is coming because as part of the investigation before the district makes a determination that a family is not residing in the district, usually you reach out to them and what they tell you is part of the investigation, right? So usually there's people that don't show up or not showing up because they didn't have notice of a hearing. And if a family does ultimately have to go to a hearing and we get to a hearing and the family's not present, the district actually has to put evidence on the record to establish that we met the notice requirements, the threshold issue that a hearing officer has to determine. Did the district meet its burden in notifying? Ultimately, I don't know the exact number of families that were impacted by that prior board action, but after that meeting, a number of families brought their documents in and applied. So I suspect, I don't know, I see Ms. Keenes on the line here. I don't know if she knows that number in terms of how many families we had, but I don't think it was that many.
It wasn't that many after the board approved for the disenrollments. Maximum of 2 were actually disenrolled, and one of the families did actually reside outside of the township, and we got a records request for them.
Which means that they went and enrolled in the school district where they do reside, and that receiving district requested records here.
Thank you for the clarity, because I acknowledge that there, the how in terms of the specific requirements behind the communication method. I guess my thought was more around acknowledging the scheduling or the date of the actual, date and time of the actual hearing, right? That somebody, okay, it's going to be on that date and time, got it. But I get the point, certified mail, email, and some other contact where there is engagement along the way. It's not just kind of like letting the carrier pigeon fly and just assuming that it makes it to the location. And I get that because it comes before we get to that point through the steps that we're taking to evaluate, why a student might be in the situation where their resident status is being challenged.
And usually in connection with the residency investigation, you know where the child lives, because that's also something, it's hard to have a hearing and say you don't live in the district when the district doesn't know where that child actually lives. So let's say, for example, there's a student that is in school in Cheltenham, but is actually residing in Ambler in a neighboring district. When the hearing notices go out and when the communications go out by mail, we send them to both the alleged Cheltenham address, but recognizing that we believe that that's not where the family lives, all of that mail also goes to the address where we do believe they live in Antler, for example. And sometimes that's actually a helpful piece of information to know, because sometimes the family will sign for the certified mail in a neighboring district. And that's just a piece of information that helps confirm or call into question the determination.
Got it. I appreciate the clarity. Thank you.
And board members, Roman? Any members of the public? Comments?
What does the timeline look like on?
So residency investigations are inherently difficult because the district's burden is pretty high. We have to be able not just to show that someone's not living where they claim they live in the district, but also that they're residing outside of the district. And, family situations are different, right? So sometimes people might be staying a day a week with a relative, and you really have to look at residency over a long
Once you're
period of
fairly
time.
certain that they're
Once you're fair-
outside of the district, what does the timeline look like between then and
Usually
determining?
a hearing gets scheduled within about 2 weeks.
Okay.
And then there's a couple weeks where there's a decision that's drafted, and then the board meets once a month. And so those would have to get approved by the board. There is, just for the committee's, information, there are a lot of pending cases currently. As I just noted, like, these cases are hard, but I was here today and I was talking to Miss Gray, who's the registrar, and she was saying that as the law continues to change, like, there's a backlog. So there's 40, 50, 60 cases at any one time where we're either getting returned mail, or sometimes what happens is someone will be living somewhere and then presumably they move out because we get an enrollment from a new family who has kids and they've moved into that same house. So there is a lot of work that's done, but it's done in a way the board can probably see. You don't get that many, you don't see this hit your board agenda very often. And the reason is because I think, first of all, the district doesn't bring cases to a hearing unless it's a really clear case of non-residency. And number two, we try internally. I know Ms. Keene and I coordinate quite frequently, and we coordinate with the building principals that once we have our evidence, a lot of times we will sit down with the family and sort of put it out there and work with families to find like a natural transition, right? So if it's 2 weeks from the end of the marking period or 3 weeks from the end of school, and sometimes when you can have a calm discussion, many of these cases do resolve on their own.
Any other comment?
There's no hands up.
As, just before we move forward, probably not a specific answer to this, and that's all right, but is it often that the district is initiating these investigations, or is it mostly complaints that are then investigated?
Ms. Keene is on the line. She could probably indicate kind of like where the complaints come from. Usually my experience is usually it's returned mail, or there are times when we get, particularly from some of the larger like apartment complexes, we get their move in and their move out lists, and that helps us welcome new families and see which homes are and apartments are turning over. So sometimes you cross-reference those lists to make sure that students are in the right place. I think it's less rare that we get an anonymous tip they're usually based on either objective evidence or something that a teacher or a school official reports, usually that comes from the child.
Yeah, that's helpful. And it also, years going, we've had other conversations, obviously, that even predate
Yeah.
my time on the board around this very topic. So it's helpful to kind of get some context around how
Yeah.
that is coming about more recently than some of those other conversations. I think we're good to move forward.
So the next one is let me just make sure we don't have any hands online.
Oh, hands online.
No.
Okay, so 200 is the enrollment of students policy, and in this policy, there was previously a provision where if you were enrolled on what's called a student support affidavit, which is cases where an adult is registering an adult that is not the parent or guardian of the student, is registering the student because there is no parent or guardian, right? This non-parent or legal guardian is essentially standing in the shoes of a parent. It could be parents that are deceased. It could be parents that are incarcerated, parents that are hospitalized and for a period of time aren't caring for their children. And previously in the law, there was a provision that said, if it was determined that that paperwork that adult individual had signed was not accurate, the quote due process that you got, the hearing was not necessarily a hearing before a hearing officer. There was an internal process that the administrative determination could be made, and that was all the due process that was required in the cases of those sworn statements that would be submitted. Now, all cases when a student is enrolled and before there's going to be any disenrollment, the procedures that we just talked about have to happen. A hearing or a court order, this internal process is no longer applicable.
Any questions or comments from the board? I'm gonna check twice because you caught me last night. Check, you raised your hand up. Check. Any comments from the board?
We also, I just want to note, we also added change of address procedure. So these are students who are, a lot of times where we actually see this more frequently is students who are actually moving from one residence in the district to another residence in the district. And there is sometimes confusion or parents don't know that they have to alert the district to that change in address, but that's important information for the district to have on file. So we realized that there was not a point in policy that we could point to when we were asking families to fill out a change of address form or to update their address. We couldn't point to a policy requirement. So we wanted to just put that in there that when you're moving, it's important to let the district know ASAP of that move.
Any comments from the board? Given there are no changes to the policy itself, is this something that we have to approve? Or is this?
So there were no changes to the policy. However, something changed in here. Legal citation.
So would that even amount to a substitute?
So this one can, the policy can actually remain unchanged and the board agenda could just reflect the AR. The only benefit of moving the policy through the process is it puts a new date on it, but we're only about 8 months out of date here, so.
You want that 95% to go to 95.9% review.
Let it go through unless
we
there's
need actually some things to
right?
review. Actually.
Yeah.
All right. But the decision is kind of to move it forward.
Sure.
Okay. All right. Any comments from the public on 200 students?
There's no one on the Zoom.
So that will move forward for first read and we can go forward.
Okay, so 005. This was actually a change in the law that, find it here. There was actually a typo in here, first of all, with respect to the treasurer. So treasurer cannot be a member of the board. So that was a typo that was in there before, which we corrected. This language here about officers of the board, this is a new provision of the school code. There was a case where there was a board president that was removed during their term, and that board president litigated the removal during their term. And the court in that case held that officers of the board, whether it's the president, the vice president, the secretary, the treasurer, they can only be removed during their term after getting notice of the reason why they're being removed and to have, you know, an opportunity to be heard before the board. So that was case law that was decided in Pennsylvania. And so previously this language in the policy said something to the effect of officers of the board serve at the pleasure of the board and can be removed at any time. And there was a case that was decided that said you can remove officers of the board, but there is a certain level of due process, that you have a certain property right in that office that was given to you for a specific term.
Intriguing. Any comments from the board? Commissioner Burdell?
Just one, and I may have missed the reference if it is referenced in meetings somewhere, but I do know that there was the removal of December for the reorganization meeting in the paragraph around elections to vice president. And I recognize that there is some time-bound date by which in fact we do have to have that meeting. And I don't know if it's referenced somewhere else. I know we have a policy on meetings, but I didn't reference that, so I apologize for not having that information available. Is
the organization meeting every year has to be in the first week of December. I think it was actually
It says
because
it at the top.
during the first week in December. Okay.
Yep. And the case that I had just talked about, we actually put in the references here. It was with the Jim Thorpe Area School District. It was a 2024 decision.
Got it. Thank you.
Sort of an intriguing case, something you wouldn't see usually litigated to the Third Circuit.
Yeah,
Federal
we
court.
describe it as like property right.
Right.
I'm not gonna ask, but yeah, definitely intriguing. Definitely intriguing. Any comments from members of the public on 005?
There's nothing on Zoom.
Nope. We got two more here. So 304 is employee resignations. And we wanted to be clear here. This was a PSBA recommendation, that it be very clear in policy that once a resignation, and resignation includes resignation in lieu of termination, negotiated resignations, resignations for purposes of retirement, to make it very, very clear that once an employee submits their resignation and the superintendent or the designee usually being the HR director or the HR office, you can't undo that submission of your resignation. And there was a case that was litigated where an employee had submitted their resignation. It was accepted administratively, but before the board sort of acknowledged it, it was revoked. And so PSBA's recommendation, even though our policy kind of said this before, was to be explicitly clear that once your resignation is administratively accepted, it's accepted. The board action to recognize it is sort of a formality that takes place after the fact.
Any comments?
And we added provisions in the notice section of the AR around timelines for and what's required to be in a resignation. So it has to be in writing, it has to be dated, it has to be signed. Those types of things are what create sort of a contract. The contract being to resign.
Any comments from the board? Any comments from the community?
Let's see.
No.
This will move forward for first read. Move forward to our final piece. Our
Yes,
final
so
item.
so the final one here is the foreign exchange students policy. And I think I had, there's just one change here. So for students that have an F1 visa, that's a type of visa that in order, as I understand, in order to have that visa, you have to have an educational institution that issues an I-20 form. The district, and I'm not aware of any public school district that is a district that is authorized with the federal government to issue an I-20 form. And the assumption always was that the organization that issued the I-20 form was the organization that where you were going to be seeking enrollment. But Ms. Keene and I recently navigated an interesting enrollment inquiry where it wasn't really the student's visa status that was relevant. It was actually the parent's visa status. And because of the visa status that the parent had, the students were able to come along. And as the district is not in the business of collecting visa information, we just wanted to make clear that while we can't issue an I-20 form, if you otherwise meet the requirements of board policy to the relevant age, proof of residency, and immunization, we process the enrollment. And it's clear in our enrollment of students policy that one of the things that school districts do not ask for is any sort of visa or immigration status.
Opening up comments from the board. Any comments from the community?
No, there are.
Right. Recognizing those, will move forward for first read and we'll return to the policy committee after our next legislative meeting. Recognizing no further items. We do have some community members here, so not to belabor the meeting, but you all didn't talk about any of our policies. So did you want to mention something that wasn't?
Yes, actually, it.
And if you
sort of
could-
Relates to the last.
Sorry, if you could say your name, what area you reside in Cheltenham.
That makes it real clear.
Both of you, and then make your comment. That's a legal requirement. So if you can say your name, the
My
area.
name
and
is
then-
Mary Jo Slovaki, and I live at 7737 Mill Road in Memphis. This is my colleague, friend, Amy Free.
In Freeville, just 14 Landfair Road in Cheltenham, East Cheltenham.
And then, yeah, please.
I realized it's towards the end here. I wasn't sure where to jump in. Maybe earlier I should have, but Amy and I want to say thank you first off for inviting public input and learning democracy. It's something that we want to bring up. We are retired Philadelphia teachers and parents of children who went to Cheltenham School District. And as teachers, of course, and parents, we always advocated for civil rights for our children, for all children and communities. And in Cheltenham, we appreciate the unique diversity and quality of our schools, especially in light of this current, especially egregious political climate. We need to be very aware of any illegal, inappropriate, or activity that might undermine that. special community we have. So we are petitioning this board to ensure that our school personnel are protecting students' rights regardless of resident status. They must have a thorough understanding of the protocols that are in place if ICE encounters occur. And all day I've heard of this happening in different school districts. For example, I want to read a policy that the district of Amherst in Massachusetts adopted. And their regulation is that if any ICE employee or employee of another agency acting as immigration agents, blah, 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 intends to enter Amherst, Pelham, or Amherst Public School property, they must first notify the superintendent of their intention and provide copies of the warrant signed by a judge or magistrate. So the superintendent can take steps to provide for the emotional safety and physical safety of any students. The superintendent will also consult with general counsel when ICE attempts to enter district property. Also, close to home, in Allentown, they have adopted a school policy which states that in compliance with the law, the district shall not inquire about the immigration status of a student as part of the enrollment process. Here in Cheltenham, we are a fortunate enclave, and our families should never live in fear, intimidation. We've recently learned of ICE agents outside of a Philadelphia school, de Burgos specifically. And I know we're not Cheltenham, or we're not Philadelphia, but the threat to our communities is real, and it is occurring. And we need to be prepared to protect our children. We need to be properly informed, proactive, prepared to act in compliance with the laws and the Constitution. An adoption of a resolution that welcomes and protects our families, I think, is urgently needed. Other cities and communities have done this, and they've stood up to any deportation, intimidation by adhering to these resolutions. Our schools are an important place to circulate accurate information and set the tone of an amenable Cheltenham. So that is our statement. Just concerned about protection of children going forward, and we would hope that the district would be proactive as Cheltenham always is with student advocacy, and have some kind of resolution in place, because the threat is real.
I'll respond, and good evening.
Good evening.
Dr. Scriven, superintendent here. So we just had a meeting today with Montgomery County superintendents, our MCIU, and other agencies, where in many districts, some of what you propose are more so protocols that keep individuals aligned to what their standard operating procedure would be if there would be a visit from ICE at any of the district schools. So that is something that I will be presenting to our Board of Education for their review and consideration. We are early in the process. We're really attacking the immigration piece of this first. And we'll be working with our solicitor. This meeting was with a different solicitor who also works with many schools. In terms of really seeking their guidance I'm going to be very transparent because that's just who I am. A lot of individuals are very hesitant to put out resolutions right now because they are fearful of having targets put on their back. When we get to that point, that is a courageous conversation that we will have to have as a board, but we're not quite there yet. First thing for me is to get the protocol in place for all of our school, all of our leaders, so that they know what process. Very similar. It's going to come up to me before anyone would be able to enter any of our schools. What's so unique about Cheltenham with just 7 schools, it's either going to be me or my assistant superintendent that are going to go directly to the school and deal with that situation firsthand. So that's where we are right now. Very, very um, deeply in tune to all these moving pieces. It's going to be complex, and we're really going to have to be able to pivot as we're bringing closure, even with this meeting. Something that we are going to have to consider, and there's been dialogue with this board already, is that we're going to probably have to increase our policy committee meetings to monthly. We had gotten away from that. But in order for us to have a quorum or a forum to have these dialogues and to be responsive in a way that we're proactive and not reactive, we're going to have to meet more. So I seriously doubt that our next meeting will be in March. It will probably be in February to be determined. But these are some of the actions that we're going to have to take to try to stay ahead of this. So, but thank you for your advocacy and thank you for your service in Philadelphia schools. Yes, ma'am.
Yeah, I appreciate that. It's a shame that you would think about, becoming a target because you are doing the right thing.
It's very real though.
Yep,
Yeah.
but is there something, well, I guess we would have to react if and when it would happen, but I would hope that there's like conversations with personnel in the school that they would know.
Oh, without a doubt. That's going to be part of the protocol.
Yeah.
Yes, ma'am. You had your hand up?
Yeah, when you say protocol, can you elaborate on that a little bit?
Yeah, well, it's a lot of what was just mentioned. One, we have to check the credentials of the ICE members. Are they truly ICE members, right? We're not going to take that as an assumption just because they're in an ICE uniform. Identification would be taken, names would be taken, copies of that identification would be made. The principal would be summoned to the office. Calls would then be made immediately up here to administration, where I would either be contacted or my assistant superintendent. The validity of the warrant would then have to be checked. There's a certain warrant that is honored. There's another warrant which is not. Training our staff in terms of what is the difference between the two. And then what are the protocols for then notifying family members or / guardians? A lot of individuals are not trying to make this a public situation. So if everything checked out and this was authorized, signed off by a judge, that's going to be Googled, validated. And then they would, if allowed into the schoolhouse, would be in a secluded area where we could then do our due diligence. Our solicitor would be notified. And there's a series of checks and balances that would continue before we took any further action.
Can I ask about data sharing? Is there any data sharing? I'm not familiar, first of all, whether
No.
you know of the status of the students or the students' family.
No, that is not something that we mandate or ask for as a district. And again, there would be need to be some type of subpoena or warrant for us to even go down that path. Yeah.
And Dr. Skirvin, just for clarity, I pulled it up here. I pulled up our enrollment policy, just for clarity. Our policy already stated, this is not a change, and this is state guidance. District staff may not request any of the following. We may not, and we do not. Social security numbers, visa of student or the parent or guardian, or immigration status. Those things are not requested. We don't have them. They're not housed in our student information database. It's not information that we collect. It's not information that we're allowed to collect. So hopefully that's a source of comfort knowing that we don't have that data. So therefore there could be no sharing of it.
Right. That's, yeah, I would imagine most school districts have that, you know, as a policy. Just completely, can be so shocking and so intimidating to have, you know, in the moment to, oh yeah, about this child, you know.
No, but the thing is that data doesn't even exist, so that error cannot even be made, no matter how shocked anyone is, so, okay.
Within this protocol, is there going to be plans to promulgate the information to make sure the teachers are aware? So if they are approached on school grounds or someplace where, you know, it's not so clear what the chain of command is.
Yeah, there's gonna have to be a full communication protocol throughout the district and all faculty and staff within the district for sure.
And in that same vein, you know, one thing that's being circulated a lot is they call it a little red card. I'm sure you've heard about it.
Yes, ma'am.
And whether that is something that I would like to see the school district become proactive in sharing with parents at school meetings, so they are aware of what their rights are.
To be determined.
What?
It's gonna be to be determined right now here. We're not there yet. You're asking great questions.
Yeah.
I'm fully aware of all that you're mentioning. But this is going to be happen in iteration, and
I would urge that the school district act as quickly as possible. I do believe that the current federal administration is not waiting on anyone.
understood.
Thank you.
Understood. Yes, ma'am.
Certainly appreciate, do we have any other hands or anything from the public before we close out?
No.
Certainly appreciate everyone's engagement tonight. Invite you to come back February, March, our future policy committee meetings. We also have other committees, educational affairs, finance, facilities, where we welcome community participation at each and every one of those instances. And just to respond, some of why I'm one board member here, but some of why I have trust in what's being said tonight is because when we hear the superintendent and an assistant superintendent will be some of the first to respond. Our superintendent is a strong operational leader. And so in terms of getting standards of procedure in place, ensuring that a communication protocol for who needs to know and ensuring that we're aligning our efforts, that's a huge part of our work across the district. And so I have some trust that as it relates to this, we have a leader who knows how to get that done at a system level. And then our assistant superintendent is legally astute. She has specialization in special education and things like that, but she's a lawyer. And so when it comes to following procedures, knowing the boundaries and where we can stop and where we can, where we can flex our authority, I have a lot of trust that we have leaders who are going to do right by our students and everybody within our students.
That's paramount.
Yeah.
Thank you.
And so with that, I'll await a motion to adjourn.
So moved.
Have a second?
I'm allowed to, I'm not.
Oh, yeah, with the members, I guess it's one of you.
Second.
Yeah, second, and the meeting is adjourned. Thank you. No, it's not.